The last 72 hours has shown us why Ken Paxton is so desperate to keep his case in the court of public opinion. Because he has no ability to win in a court of law. See, in a court of law, a judge will preside over that case and he will be treated just as any other civil or criminal defendant. Witnesses will be under oath for all the world to see. And this past Wednesday, 2 investigators and 4 career prosecutors with decades of work in public integrity and white-collar crime revealed that they had confidentially been interviewing witnesses and reviewing evidence into Attorney General Ken Paxton for months. Public integrity means looking into and prosecuting elected officials who have used their office for their own gain. This body, we, have passed numerous laws to protect the public from corrupt officials like abuse of official capacity, official oppression, misuse of official information, bribery, and corrupt influence, all of which we have here. White-collar crime, not your pickpocket, the use of complex systems that can destroy companies, wipe out people's life savings, cost investors millions of dollars, and erode the public trust in institutions. Crimes like mortgage fraud and securities fraud. These are not new concepts to the committee's investigative team, but their discovery that the state's top cop is on the take was and is extraordinary. Criminals have an MO, a modus operandi, a method of operation, just like any common theme of a thief, a rapist, a murderer, where they have patterns that can develop over time. And Paxton has shown over time he has a power in his ability to not respond until caught. Once he has learned he is caught, he will often lean on political friends, delay the process he could to avoid the courtroom, and lie to the public for almost a decade, thinking his reelection served as the ultimate get-out-of-jail-free card. We sit here to judge like any other grand jury to decide whether or not we want to move forward. And criminals rarely confess. That is why we don't have to prove motive, and we don't have to prove cases in any other way than ideas such as circumstantial evidence. And so let me explain circumstantial evidence. We have all been in the grocery store, and I want you to imagine that you turn down the aisle, and as you start down the aisle, you see another person coming the other way. They're pushing their buggy. They've got a child sitting there in the top of it. They're reaching up for items. They're looking down at their list, and as you get to each other, "Oh, I'm so sorry. Are you okay? I didn't mean to hit you." Do you think that they meant to hit us? You can see all the circumstantial evidence around it and say, I don't think they meant to hit us. Now let's take that we turn down the aisle, and on the other end of the aisle there's a cart coming, a person pushing, no distractions, no baby, no list, and they're coming right for us. And we move over the other way, and they come in our lane, and we move over the other way, and boom. I'm sorry, I didn't mean to hit you. Do you believe that? It is the same analysis that we go through in looking at an entire timeline when determining criminal activity. We also are not required, when a potential offender tells us a statement, that we have to take them at their word. We look and we are responsible for evaluating and looking at all the circumstances. And so let's take a look at what's happening with Texas Attorney General Ken Paxton. It's around October 2020, and the office is beginning to scramble in a crisis. Calls are starting to come in because there are agencies and entities receiving subpoenas that they are wondering, what in the hell are you doing? Are you really looking for this kind of information? At that point, they are aware that there are more than 30 subpoenas that have gone out to banks asking for loan information, checking and saving account information, personal cell phone data of bankers, investigators, and a judge. They begin to recognize that these subpoenas are supposedly authorized by Brandon Kamick. Who the heck is that? You have these entities of operations of men who have been in different silos who all come together, and they all, at that point, sitting around with each other, realize that there is a common thread that they are hearing, and they all perk up. They realize the conduct that the Attorney General has independently been committing with each of them over a course of a number of months. All roads lead to Nate Paul. All of them recognize through their own independent discussions with the Attorney General, they have warned him, Nate Paul is no good. You can do a common Google search and see his bankruptcies, and there is no way you should have anything to do with him, and there is no way this office can participate in anything on his behalf. Article 1. When Ken Paxton asked the Office of the Attorney General to interfere in the Mitty Foundation, as Representative Spiller has spelled out, he turned the Attorney General's office against a nonprofit. As the lawyers for that nonprofit said, quote, they felt ominous pressure, being forced to attempt to settle on the cheap to the benefit of Nate Paul. When the Office of the Attorney General suggested that they settle for $5 million when they had a $10.5 million already recognition of Nate Paul was supposed to provide, and then later being recognized that the value of that case to them was $21 million. You heard from Representative Spiller that unusually Ken Paxton involved himself in these matters in a way he had never before done with regard to a charitable entity. He broke the fundamental rule that this body has passed to say that the Attorney General will protect nonprofits for the interest of the vulnerability of all Texans. And in this case, he turned that on his head, represented his friend, and he broke the law. This article represents abuse of official capacity, which is a third-degree felony warranting 2 to 10 years in prison. Article 2, when Ken Paxton asked the Office of the Attorney General, as Representative Spiller just displayed, what they called the midnight opinion. Nate Paul has 13 properties that are in foreclosure, and they know that he has one or more set, or he knows that he has one or more set this next Tuesday. They go scrambling, and they originally write an order that says there is no need for us to shut down. Ken Paxton says, no, do it the other way. They acknowledge to him and say, you do get that we're going to say that while it's COVID, that 10 people can't get together outside for foreclosure, and that goes against every other policy that was being issued at the time by the state with regard to COVID. They issue it anyway. When Nate Paul is deposed and he is asked, did you have contact with Attorney General Ken Paxton before that order was done? Quote, yes, I had contact with him before that, end quote. Ken Paxton, he broke the law. This is misuse of official information, another third-degree felony warranting another 2 to 10 years in a prison. Article 5. When Ken Paxton sets up this rare lunch, he asks the Travis County DA's office to sit down and meet with Nate Paul. He makes a personal introduction. As a courtesy, the Travis County DA stays. They listen to Nate Paul and they think there is nothing here for us to do to investigate. He insists that he wants them to try to help him because he believes that he has been falsely accused and needs to get access to information with regard to the FBI. They require that you give a sworn statement. And the reason they want you to give a sworn statement is you want to try to prevent people from using law enforcement agencies for false and vindictive purposes. He doesn't give a sworn statement. Travis County says, nothing for us to do here. There is no there. There's no case there. Ken Paxton then assigns Mark Penley, Deputy AG, and David Maxwell, the Director of Law Enforcement, to meet with Nate Paul and to meet with him. They again tell Ken Paxton, quote, no evidence of a crime and no state interest, end quote, is here. There is no reason for us to get involved or have anything to do with this guy or his allegation that the federal government has tampered with him. Ken Paxton insists, do it again. At this point, Nate Paul comes back and he has some records that he suggests have been tampered. The Attorney General's office then has an expert go through the point of doing analysis on the document and again comes back and says, there's nothing wrong here. This document has not been tampered with. Ken Paxton says, I just need you guys to meet with Nate Paul and tell him. They again sit down in a room with Nate Paul, Ken Paxton, and these senior officials, and they say, look, there's nothing here that this office can do for you in this circumstance. They describe that Nate Paul gets, quote, incensed, end quote, and, quote, dresses them down, senior staff, like they were his employees, end quote. These two men for decades say, we're not getting involved, we're not doing this. As Representative Spiller said, there are some 800 lawyers that can engage in criminal issues. Ken Paxton, Freudian slip, decides that he's not going to let it go. Ken Paxton is going to now look at two different individuals to hire to act as a special prosecutor, one of which is decorated, decades of experience in prosecutorial experience, and the other is a 5-year lawyer, defense attorney, and never been a prosecutor. Guess which one gets hired? The guy that's got no prosecutorial experience, and it's because he comes at the recommendation of the attorney who works for Nate Paul. Ken Paxton sets aside money for this young individual to work, and he tells Penley that he needs to hire him. Penley refuses and will not sign the contract. He says no. Ken Paxton again asks on a Saturday, come meet me, I want to talk with you. They meet in McKinney, and when they do, Penley again warns Ken Paxton, quote, you are exposing yourself to potential criminal liability, end quote. He says, do not do this. And Ken Paxton says, you got to sign the contract. He's been working for 2 weeks. He needs to get paid. Penley then says, fire him. I will not participate and I will not supervise this guy. And Ken Paxton responds, quote, don't worry, I will, end quote. The grand jury subpoenas that are put out include bank records, individuals, and contacts as already recognized with regard to investigators and a judge in a case involved with Nate Paul. This raises serious questions about the release of public information. It raises serious questions about exposing a search warrant. And why do we have search warrants and why do we redact them? Because we appreciate law enforcement. We appreciate those witnesses that will come forward in the interest of justice, and we do not turn over those files to a target because what can happen? Witnesses can be tampered with and evidence can go missing. It is a fundamental tenet of offices of prosecution and law enforcement that you do not expose those individuals. But as Representative Spiller has already indicated, there is a correlation between the access of that unredacted file and Ken Paxton to Nate Paul, and sure enough, it is those individuals and their information that's being sought in this warrant. One of those investigators later goes to get his car fixed. And when they get the car fixed, you know how they raise it up? He says, hey, can I take a look underneath? And finds a tracker. And finds that that tracker has been active in searching, and it's been on around the time that these things start happening. Ken Paxton broke the law. Misappropriation of fiducial property, which is a state jail felony, carrying 6 months to 2 years, and another case of bribery, carrying a second-degree felony of 2 to 20 years, and abuse of official capacity, another third-degree felony carrying a punishment range of 2 to 10 years. Article 3 and Article 4, when Ken Paxton asked that they issue this no decision, when you have the receipt of the manila folder that he has for 7 to 10 days, when we know, like any other criminal who wants to cover his tracks, he doesn't hand it to Paul himself. He gets a young aide, gives him the package, and asks him to deliver it to Nate Paul at one of his Austin businesses. Ken Paxton, again, broke the law. Misuse of official information, abuse of official capacity. Again, an additional third-degree felony warranting 2 to 10 years in prison. When these whistleblowers, these individuals find out what's happening, they begin desperately to start cleaning up Ken Paxton's mess. They recognize that those 39 grand jury subpoenas that go out, and let me explain how this happens. The Attorney General typically will assist in other counties. So it is not unusual that they went to Travis County and they said, I need to issue these grand jury subpoenas. A grand jury subpoena carries weight. It means you must comply. And if you don't, you're in violation of the law. It was issued by, quote, Special Prosecutor Brandon Kamek, and it was signed by a judge. It is the Attorney General's office themselves, these entities, these individuals who started to see when it boiled over and realized what was happening around Nate Paul, that they go file motions to quash. A motion to quash means I'm telling you, you no longer have to respond to this order, and in doing so, they say that the individual that had submitted them did not have the authorization and should not have done it, and they should not comply with that response. Articles 9 and 10. Articles 9 and 10 relate to the issues of the affair and the renovations. Why is the affair important? The affair is important because it goes to Ken Paxton's political strength. He knows that with his folks, he is family values. He is a Christian man, and the idea of the exposure of the affair will risk him with his base. In fact, when the affair comes out, there are a couple of people in the office that say, I can't work for you, and I'm leaving. He has an interest in attempting to keep this affair quiet. He also has an interest in continuing it. Another staff member says that he comes to them distraught of how he is continuing to be in love, and she tells him, what the heck are you doing? You are exposing yourself, and you are exposing this office to potential blackmail and potential influence, and you can't do it. The other benefit is that Nate Paul giving his mistress a job means that he no longer has to drive back and forth from San Antonio to see her, and it makes her more convenient and here in Austin. With the renovations, you may have heard part of the story with the renovations is that they have a home here in Austin that is undergoing floor-to-ceiling renovations. The idea of this is that there is a young man with Ken Paxton. He normally has a security detail, but he starts doing things without that detail, and he starts doing things that are not on his schedule. One of those things is going to this renovation house, of which there is a disturbing encounter. This young man realizes that as they are standing there in the home, and Ken Paxton says, hey, we want to change out these countertops and get something else. And they say, that's going to be like $20,000. That's all right, go for it. The contractor says, I'll have to talk to Nate. This young man is disturbed by it. In fact, he's crushed by it. He believes Ken Paxton is one of his heroes. He is a leader of the Republican Party, and he is the Attorney General. This young man is bothered by it enough that he eventually asks him and says, hey, what was the deal with that? And this young man does not get an answer of which satisfies him. The whistleblowers now come forward and disclose their information. It is after that that this young man is offered a promotion. He declines, and he leaves the office. After he leaves the office, he continues to get a stipend. and a check from Ken Paxton's campaign for $250 a month. He calls repeatedly, says, I don't want this money, please stop it. It goes on for about 4 months. At the point in time that it finally stops, he writes a check and he sends it back to the campaign without anybody knowing about it. This is the kind of integrity of the people that we describe when we say that the committee investigators have met with more than 15 people, many of them Republicans, many of them who worked in the office as civil servants, and many of them deeply conflicted about the information about what they had to disclose and the individual, because each of them, almost to a fault, attempted to remain loyal and help Ken Paxton. In these 2 articles, again, Ken Paxton, he broke the law. He received an improper gift to a public servant, a Class A misdemeanor carrying up to a year in a local jail. He again has the appearance of bribery, a second-degree felony. You all get to judge, like that cart coming down the aisle. Are these just individual isolated incidents of which you can dismiss, or are they an unexplainable pattern of ongoing criminal conduct? Articles 12, 13, 14, and 16, these relate to the underlying securities fraud, failure to properly disclose and register. And I think that Speaker Guerin said it best in our hearing if you were watching, because at one point there was a discussion about a $100,000 gift given to Ken Paxton. And the issue was the fact that he originally did not disclose it as a securities operator to say, hey, I have a vested interest in what I'm getting, and it's either an improper donation and disclosure, of which he is aware of the laws and obligations for transparency. And when he gets busted on that, he says, no, it's just a gift. And somebody says, what do you mean it's a gift? And he says, I met a guy in a Dairy Queen, and he told me God told me to give you this $100,000. Speaker Guerin said it really well. I have never had anybody come up to me and said, God told me that I should give you $100,000. That's not the only $100,000 incident. There is another $100,000 gift, which is a donation to his legal defense fund, and there is another questionable securities issue gift with regard to the Maori Corporation. We see, like in those circumstances, that it is his opportunity to delay and extend the court proceedings that keep him from never having to go to court. We bring those incidents to you to look at that whole aisle, to determine the course of conduct that he has set in motion for almost a decade. Is that part of his MO? It is when he gets caught in those circumstances that he will say, oh no, I'm sorry, I forgot, I didn't realize, I should have registered it this other way. There are probably a lot of folks in here that speed. You may have a lead foot. And I now want you to think about how many tickets you've gotten, because you've spent a whole lot more than you've been caught. And these are 3 instances of payments of large amounts of cash to a man that he did not attempt to correct until busted. Articles 6, 7, and 8 deal with the whistleblowers. These individuals who were doing everything they could on behalf of the state of Texas and everything they could on behalf of that office, they were fired. They were not only fired, they were shamed. It stained their reputation and it stained their careers as great public servants and law enforcement officers in an attempt for Ken Paxton to save his own skin. Through this investigation, those individuals have been talked to, but I will tell you there are others. There are those that are not yet brave enough to come forward, and we won't judge them. Because it's almost like, why would you? This guy has gone almost a decade manipulating the processes, throwing false narratives out, and almost proving himself to be untouchable. We see that same MO starting now. Complaints of process, and I haven't gotten to tell my story. This is his story. This document, almost 400 pages, was sitting on his website for years. This is his answer to the whistleblower's complaint. This document went missing after we said, don't do anything with any of the evidence in this case, and you are currently under investigation. I guess it is hard to walk into a committee and claim nobody has asked you any questions or looked at process if this sucker's still sitting on your website. It is gone, and it is illogical that somebody wouldn't have realized that we would have printed out a copy. Not only did we print out a copy, but the committee investigators reviewed this report, and in the hearing, you can start on page 124, line 10, and you can go all the way to 130:19, where the investigators say not only did we review everything and talk to the witnesses involved and looked at the evidence, but page 46, false claim. Page 5, false claim. Again, page 5, false claim. Page 49, false. Page 5, misleading. Page 49, false. Page 50, false. Page 6, false. Pages 5 and 6, false. Page 42, false. Page 52, false. Page 7, misleading. Page 39, false. Page 39, again, false. Page 39, false. Page 39, false. Again, accusation, false. Accusation, false. Accusation, false. Page 34, false. And then asked, do you want me to keep going? Please. False. Page 52, false. Page 56, false. Shockingly or not shockingly, Ken Paxton's office investigation into whether or not Ken Paxton committed his own crimes has been and recognized to be repeatedly false. Again, with regard to the whistleblowers, Ken Paxton, he broke the law. Retaliation under our government code is a felony of the third degree carrying another 2 to 10 years in prison. Official oppression is a Class A misdemeanor warning a year in a local county jail, and the government code 55.4.002 of the whistleblower statute and civil penalties. Articles 16, 17, and 18 go to the ideas that this gentleman is no longer fit for service or for office, that what he has done has impugned the integrity of our court system and those who have worked very hard to keep it functioning. We asked a question to the committee investigators about what they found about those whistleblowers and the courage that they demonstrated. Quote, the thing that I think struck all of us in our investigation, not only in speaking with whistleblowers, but other high-ranking officials at the Attorney General's office, is that these are individuals who are extremely well-credentialed and qualified. These are individuals who had taken upon their role as public servants to do their oath. Is what their oath asks them to do, to uphold the laws of the state of Texas and to uphold the Constitution. Many of the people that we spoke with, specifically some of the whistleblowers, are known outside of the office of the Attorney General's circle. They are well-respected former law enforcement. They are well-respected attorneys. They're individuals who are considered subject matter experts in the field, and they are oftentimes the cream of the crop. They rose to the positions that they are in because of their work ethic and because of their dedication. And the feeling was shared almost universally that the actions that they were being asked to take, the positions that they were being put in, and the decisions made by the Attorney General sullied their office and sullied their commitment and their careers. I've had the opportunity to work in criminal courts for almost 20 years, and I feel for you in the same way that I feel for jurors. Nobody asked to have to be brought in to make these judgments. But I will say it is not you who asked to be here, but it is the person who continually broke the law. And that man is Kenneth Paxton. This story now comes to the fork in the road for all of us. And either this is going to be the beginning of the end of his criminal reign, or God help us with the harms that will come to all Texans if he is allowed to stay the top cop on the take. If millions of Texans can't trust us to do the right thing right here, right now, then what are we here for?